Good evening, everyone, and welcome. My name is Pam Minetti, and I am honored to serve as the president of Illinois Women's Institute for Leadership Training Academy. On behalf of our board, staff, and alumni, thank you for joining us for our annual Dawn Clark Netsch Policy Forum. This year's forum topic, Lawfare, Courts, and the Future of Democracy, could not be more timely. Across the country, we are seeing political conflicts increasingly played out in courtrooms, from challenges to executive authority to voting rights and immigration. Tonight, we want to shed some light on what's happening in the judicial branch. And we're very excited to have Carolyn Shapiro, founder and co-director of the Chicago-Kent College of Law's Institute on the Supreme Court of the United States, here with us. For more than 2 decades, IWIL Training Academy has been dedicated to training pro-choice Democratic women to run for public office and lead in their communities. We believe that a healthy democracy depends on informed, ethical leadership, and that it matters deeply to have women at the decision-making table. This forum is especially meaningful because it honors the legacy of Dawn Clark Netsch, one of IWIL Training Academy's founding mothers and a trailblazer in Illinois. Dawn served as an Illinois state senator and comptroller and was the Democratic nominee for governor at a time when women candidates faced enormous barriers. She was one of the first women to teach at a law school in our country and a lifelong champion of women's rights, civil rights, and human rights. We see Dawn's values reflected in the women we train each year, women who are stepping forward to lead in their communities. This policy forum is one way we continue her legacy by engaging in important conversations reflective of the times we're in. I'm also very pleased to introduce tonight's moderator, Colleen Kilbride, a proud alumni of IWIL Training Academy's class of 2019. Colleen is an accomplished attorney and leader whose work exemplifies the thoughtful, principled leadership IWIL seeks to cultivate. She currently practices labor law as in-house counsel for the Chicago Laborers District Council, where she fights on behalf of 20,000 union members. She also has extensive experience in immigration law, specializing in representing detained and released unaccompanied minors. Thank you, Colleen, for guiding tonight's discussion, and thank you to our presenter, Carolyn, and guests for being part of this important conversation. Colleen, I'll turn it over to you.
Thank you, Pam. Hello and welcome, everyone. Thank you for making time to join with us tonight. We continue to find ourselves in overwhelming and unprecedented heavy times under this current administration. Actions taken by our federal government that would have been considered absolutely insane and unheard of continue to unfold across the country in increasingly concerning ways. Here tonight to talk about lawfare, the courts, and the future of our democracy is legal expert Carolyn Shapiro. Before we dive into questions, I want to share a little bit about Carolyn. Originally from Champaign, Illinois, Carolyn has lived in Chicago since her college days at the University of Chicago. Carolyn then went on to obtain both a master's degree in public policy and then a law degree from the University of Chicago. Carolyn is the founder and co-director of Chicago-Kent College of Law's Institute on the Supreme Court of the United States. Her scholarship is largely focused on the institutions of our constitutional democracy, specifically the Supreme Court. She teaches classes in constitutional law, legislation, and statutory interpretation, public interest law, and policy. In addition to Chicago-Kent's Supreme Court Institute, she also directs Chicago-Kent's Public Interest Certificate Program and is the faculty director of the Constitutional Democracy Project, which is a civil education project that provides programs, professional development, and educational materials to high school and middle school teachers and students. She has argued cases before the U.S. Supreme Court, the Seventh Circuit, the Illinois Supreme Court, and the Illinois Appellate Courts, and somehow also maintains a small appellate practice. Again, thank you so much for being here, Carolyn. So let's set the stage. Can you help us understand what lawfare means broadly and how we're seeing it used today?
Sure. And first of all, just let me say thank you for the invitation and the opportunity to have this discussion. The word lawfare can mean different things to different people. I think it was originally coined as a term to talk about the role of law in national security or the role of law in international conflict. It's now, I think, come to have a variety of different meanings depending on the context. Today, I think many people think of it as referring to the way in which law is brought into the significant conflicts, whether they're political or otherwise, as a kind of in some senses, a kind of trump card or a weapon, or in some cases used more defensively. But I think it's the idea, at least as I think about it, is to think about the stakes, right? If we're talking about lawfare, we're talking about something, the stakes are really, really high in terms of how law is being used, and in particular, how law is being used to manage power struggles between whether it's different constituencies or different branches of the government, um, or both. That it's about law and power.
And we're seeing political conflicts that you're talking about increasingly play out in the courts. For example, presidential immunity and birthright citizenship are two issues that come to mind. What are the implications of the judiciary becoming such a central arena for political power struggles?
Well, I think it's hard to answer that question without talking a little bit about why that might be happening, because I think there's a certain amount of um, spiraling or building on itself that's important to look at. One thing that I think is really important is that what in recent years, and not just during this current administration, Congress has really become increasingly ineffective. It's become harder and harder for a variety of reasons to pass any meaningful legislation. What that means is that congressional ability to set policy, to change policy direction, to assert itself over the other branches of government has dwindled, and power abhors a vacuum. Into that vacuum, what we see is a couple of things. One is the courts, and the other is the executive branch, that have really worked hard to fill that vacuum, rightly or wrongly. That's a big part of the story, I think, of the 21st century. So that reality has a lot of implications that I think we could spend a lot of time playing out, but I'll start with a few of them. One is, if Congress is not acting or is not effective, then then the two other federal branches are much less small d democratically accountable. I mean, some people would say, and do say when they're defending what's called the unitary executive, that the president is the most democratic, small d democratically accountable official because he's elected by the entire country. I think that is a very misguided view, and it's certainly not what the founders thought. They thought Congress was the most democratically accountable branch of government, and in particular the House of Representatives. So if what we have instead is executive and the courts that are making the really big decisions, then this most representative branch is cut out, and that's exacerbated by all kinds of ways in which the small d democratic nature of Congress has also been undermined, right, through extreme partisan gerrymandering, through the overuse of the filibuster, et cetera, so that Congress, even if it were, right, so Congress has its own problems being democratically accountable and responsive. But the less it accomplishes, the more that this power shifts to these less democratically accountable entities. Now, one of the things we're seeing right now, and you mentioned the birthright citizenship case, and another case that involved debates at the federal level or challenges at the federal level. But one of the things we're seeing that's really important as we're talking about these changes, shifts in power, is that a lot of pushback from the states. The states, which are their own sovereigns, have their own locus of small d democratic accountability. Many of them are pushing back very hard against what this administration is doing. And that role of states pushing back against things that the executive branch does predates this administration. It really became a regular feature of our political environment, I would say, during the Obama administration. So during that administration, not surprisingly, it was primarily Republican-led states, Republican attorneys general who brought lawsuits against Obama. The opposite when Trump, during his first term, the opposite back again with Biden, and now we see the blue states bringing many lawsuits against the second Trump administration. So those are all ways in which there's a shift in the sort of in the locus of power and in the locus of where the people writ large see these challenges playing out.
And are there misconceptions about this trend or anything you wish the public better understood about how the courts work?
Well, it's a little hard for me to answer that because to some degree, especially the Supreme Court is not doing things that I would have suggested what they would have done. So I'll talk about that a little in a moment. One misconception I think is that I do hear people say, and this is primarily from the right, people say, well, Trump his administration has been subjected to more preliminary injunctions and TROs than any other administration ever in such a short period of time. That's true. One inference that some people draw from that, somewhat people on the right draw from that, is that there are a bunch of what they call activist judges who are out there trying to thwart the Trump administration. Another inference some people draw from that, and that's more people on the left or people who are really focusing on the content of these cases, and I've even brought one of these cases, is although we have not obtained a preliminary injunction or TRO, is that the Trump administration is doing wildly illegal and unconstitutional things that at a pace and at a scale that we have never seen before, and that's why there's so much litigation, and that's why so many judges appointed by members of both parties, and including some appointed by Donald Trump, are imposing these preliminary injunctions and TROs. So I think that's one thing I really want people to take from this, is that the pace and volume of this litigation is unusual for sure, but it's not, in my view, attributable to judges gone wild at all.
And what do all the political conflicts playing out in the courts mean for the role of elected officials?
Well, I think this goes back to what I was saying about Congress. In some sense, it doesn't just make Congress, it sort of contributes to Congress continuing to not act. So I'll give you one example. When Russell Vought, who is the head of OMB, the Office of Management and Budget, was up for confirmation at the beginning of Trump this presidential term. One of the things that was at issue during his confirmation hearing was whether or not there would be what are called impoundments. And impoundment basically means that the executive branch decides not to spend money that Congress has appropriated. Lots of times, of course, Congress appropriates money and says, spend this money in such and such a way if such and such conditions obtain, or spend this money in such and such a way within your discretion, Mr. President or whoever. And that's fine. But sometimes Congress says, spend this money, like do this thing with this money. And impoundment is essentially the executive branch saying, yeah, we're not going to do that. Russell Vought basically made it clear that he thought that the executive branch has the constitutional authority to do that. I think that is profoundly wrong, to be clear. And during that confirmation process, it's a direct challenge to congressional authority. So you would think that members of Congress, really members of both parties, would be interested in having not confirming somebody who's going to take away their power. And obviously that's a very partisan time. People vote on party lines, but the gist of where I'm trying to get in this story, which is a little long-winded, is a quote from Susan Collins, Republican senator from Maine, often seen as a kind of moderate. She said, yeah, she was going to vote. She was concerned. She's often concerned about things. She was concerned about impoundment, but she was going to vote for confirmation anyway, because she said the courts would work it out. I think that's really irresponsible. She has an independent obligation. She's to evaluate whether or not what this guy is going to do is constitutional. It's, in my view, not. The impoundments that were authorized are part of why our foreign aid, and in particular USAID, was just completely decimated. I think a lot of that money in the end was spent through litigation. I do, just as full disclosure, I represent an association of USAID workers. We tried to stop the destruction of the agency. We have not succeeded. We're on appeal right now. So I don't want to say very much about the case, but there was a parallel case in a different courtroom that did succeed in requiring the government to spend a lot of the money that had been appropriated for foreign aid. But the chaos and the deaths of hundreds of thousands of people and the loss of jobs and infrastructure for doing this really incredibly important work, that's the price, in part, of Congress being like, yeah, well, we don't have to worry about it. It's not our job to think about the Constitution. We'll let the courts take care of it. So it kind of allows them to just ignore the Constitution to some degree.
Now, in the Department of Homeland Security v. Regions, the Supreme Court blocked the Trump administration's attempt to end DACA, which is the Deferred Action for Childhood Arrivals. Can you unpack what this case tells us about the court's role as a procedural guardrail on executive power? And with the heightened executive overreach in our current moment, are the courts effectively serving as a guardrail that we so desperately need?
Okay, so this is going to be another long-winded answer because there's a lot in that question. So first, I'll just say a word about the DACA case. Important to note that that is a case that was decided during Trump's first term. That's important for a number of reasons, one of which is that the court behaved somewhat differently during that term than it has been behaving during this term. The guardrail there was essentially that the administrative law, which the body of law that governs a lot of what the executive branch does, one of the things administrative law requires is that there be some kind of reasoned decision making, and as part of that reasoned decision making, when you're ending something that people have relied on, you have to take those reliance interests into account. And that's essentially what the court in DACA said. They said the Trump administration hadn't adequately considered all of the reliance interests that were going to be upset if it eliminated DACA. Now, one way of thinking about that is that essentially this is a procedural protection. It's not a substantive protection. So given the Trump administration's current anti-immigrant agenda, I would imagine, although I certainly have no inside information, that there are people within the administration working on the reasoned explanation for why DACA is going to go away, sort of one that would meet these procedural requirements. Another case in which the court during the first Trump administration ruled similarly was in the census case involving whether or not there could be a citizenship question in the 2020 census. There, the court basically said that the justification offered by the administration was really pretty implausible and did not explain the need for the citizenship question. So in both cases, it's a non-substantive ruling. It's a procedural ruling. So that's one thing to say. I also said in this time around, the court is behaving differently from the way it did during the first Trump administration. As many of you, probably all of you, if you're on this call, are people who pay attention to the news, so you've probably heard the term the shadow docket. So I'm going to explain a little bit about what that is. I know not everybody here is a lawyer. So when the shadow docket is, some people use that term to describe everything that the Supreme Court does that doesn't involve full briefing and oral argument. So that would include things like decisions about whether or not to take a case, to hear the case on the merits. Those are generally through petitions for certiorari or cert petitions. It might include really not particularly significant motion practice, like when people ask for an extension of time. Some uses of the term shadow docket incorporate those really quite routine types of decisions. But that's not what right now, the focus when people talk about the shadow docket these days. It generally refers to, or often refers to, the Supreme Court's ruling on what are called emergency applications from parties. When I clerked on the Supreme Court, I was really fortunate to have that experience. When I was there, we would get some emergency applications. Almost all of them came from people who were about to be executed, from capital defendants, and they were requests for a stay of their execution in order for them to file a cert petition asking the court to decide some kind of legal issue, some kind of legal question. Most of them were denied. The vast majority were denied. Sometimes, and there are still plenty of capital defendants who file comparable applications with the court. But increasingly, and in this administration in particular, what we're seeing is that the court, that the parties are bringing, this administration is bringing to the Supreme Court a request to stay preliminary injunctions, and sometimes but we'll just mostly talk about preliminary injunctions, and I can explain what that is, that lower courts have issued. So this has come up in a variety of contexts where, for example, a lower court says, the plaintiffs come to the lower court and say, it's the administration is trying to end temporary protected status for all Venezuelans. And for a variety of legal arguments, we, the plaintiffs, believe that's improper. And or the administration is not spending money on for a bunch of different programs. It certainly wasn't, that hasn't been limited to USAID. We, the plaintiffs, are entities that would receive those funds, and we think this is improper. Or the administration is firing thousands of workers and improperly. And we, the plaintiffs, the workers or their unions, think that's improper. In many of these cases, for example, there are others, lower courts have issued what are called preliminary injunctions saying to the administration, no, you can't do that. So we're issuing a court order saying you can't do this thing. And there's a whole process that they could go through, that there can be fact finding, there could be a hearing, the court has to explain itself, explain its reasons, has to meet a certain set of criteria, which I can talk about. And then what the administration has been doing in some, but not all, but in some of these cases, they go then to the Court of Appeals and they say, we need an emergency stay pending appeal. And then if that court says no, they then go to the Supreme Court, the administration, and says, we need an emergency stay pending appeal. And in a surprising number of cases, a really extraordinary number of cases in which those applications have been filed, as in almost all of them, not quite all of them, the Supreme Court has said, okay. And the reason why that's so surprising is that the Supreme Court isn't actually, almost never grants emergency applications for stays pending appeal. It's really, really unusual, or at least it used to be. And the standards are really high. And they include things like considering the balance of equities, the interests, not just of the party that's asking for the stay, but also the other parties. And the Supreme Court does not, to the extent we can tell, appear to be doing that. In many of these cases in which they're not even explaining why they're taking the action they're taking. In most of them, they don't have any explanation. But even where they do, the explanation kind of often seems to be something like, well, it's irreparable harm, which is one of the factors, to the administration not to be able to do what it wants. That's true as far as it goes. But there are a bunch of other factors that are supposed to be considered, and they just seem to be ignoring them almost all the time. And that's very different from the first Trump administration. So part of my answer to your question is, how are the courts doing with this executive overreach? Is the Supreme Court is enabling an extraordinary amount of executive overreach by issuing these stays that, in my view, are really improperly issued. The standards are not met, or I can't tell why the Supreme Court thinks the standards are met because they're not explaining themselves. On the other hand, the lower courts are doing remarkable work. And there are lots of preliminary injunctions and now even some permanent injunctions, the difference being what it sounds like, that are in place, that lower courts have put in place against this administration, that they have not taken up for emergency applications. They may appeal them, and we may yet see some of them reversed, including in the Supreme Court, but they have remained in effect. So one example that there are many, but one example is the Consumer Finance Protection Bureau, which the Trump administration announced very early on it was just going to close. Well, it's created like USAID, created by an act of Congress. You can't just close an agency created by an act of Congress if you're the executive. the judge, this group of plaintiffs went to court. The judge said, yeah, you can't do that. Imposed a preliminary injunction that limited it didn't completely limit the executive's discretion over how the CFPB was running. It still had lots, but basically said, no, you can't just lay off all of the employees. You can't just close down all of the buildings. I'm not familiar with the specific details of that. And that is currently on appeal in the DC Circuit. It's going to be a while before we know, but they didn't take that to the Supreme Court. And so the CFPB remains at least partially it's not exactly the same as it was because of the amount of discretion that the administration does have. But its complete destruction was stopped by this case. And there are lots and lots of examples like that around the country. Sorry, that was a very long answer.
Wow. There's a lot going on and it can be dizzying. So this is helpful for me to hear you lay it out like this. Are there other recent Supreme Court cases that are particularly instructive as to how these political battles are being fought in the courts that you want to touch on?
Well, I think it's worth talking about some of the cases that implicate what's called the unitary executive. The unitary executive is a legal theory that suggests that the executive branch is the president, and that Congress has limited authority to control what the executive does. I'm going to do my best to explain this theory as fairly as possible. I think it's profoundly wrong, but the way it has been playing out primarily in our current climate has to do with the president's ability to fire people he doesn't want to have working for him. So way back 100 years ago, there was a case called Humphrey's Executor in which the court said, yeah, actually, Congress can create an agency, and try to make it somewhat independent, isolate it to some extent from politics by restricting when the president can fire the heads of the agency. And by and large, these have been multi-member commissions, like the Federal Communications Commission, for example, the FTC, and they've been multi-member bodies, and they've also required some amount of bipartisan membership on those bodies. And so there's been the case law has suggested and more recently expressly held that agencies headed by a single entity that can't be the Congress can't restrict the president's removal power there. But these multi-member agencies have been independent for well over a century. And Humphrey's Executor has been sort of the bête noire of people who believe in the unitary executive. The president came in and started firing people. These people, like including at the National Labor Relations Board, at the Merit Systems Protection Board, which oversees the civil service, at the FTC, which is what Humphrey's Executor actually was about, the Federal Trade Commission, and at the Federal Reserve and some other agencies as well. The Supreme Court, even though Humphrey's Executor still hasn't been overruled, although it's almost certainly going to be very soon, stayed. The lower courts they can't look ahead, right? They have to apply the existing precedent. So the lower court said, well, Humphrey's Executor is the law. The Congress said president can't fire these people except for cause, like if they're not coming to work or if they're, that's a different story. We can't fire these people for policy reasons. That's the law. So we apply the law. The Supreme Court stayed all of those injunctions and has now heard oral argument in the FTC case, and just today in a case involving the Federal Reserve, whether the president can fire the Federal Reserve board members at will. this is really important. It goes back to what I said at the very beginning. This is about power, right? It's about what does Congress have the power to say, we want this agency to operate on the basis of reasoned, expert analysis. Yes, of course, there's policymaking. Of course, right, there should be some democratic accountability, but we don't want wild swings from presidential administration to presidential administration in this area of policy, because we think the stability and independence and expertise is really important. And this unitary executive theory essentially says no, that the Congress just doesn't have the power to do that. Now, people think, especially after today's oral argument, that they will carve out a special exception for the Federal Reserve because it's so problematic to have the Federal Reserve not have independence. But it does look like otherwise. This, in my mind, is a very significant shift of power from Congress to the executive.
Yikes.
Yikes. Yes.
From my professional experience representing immigrants and labor unions, court decisions often translate into immediate and real and life-altering consequences. How do you think courts should account for these real-world impacts while also balancing the legal doctrine and institutional limits?
So it depends, the answer to that question does depend on a variety of things, including, right, what is the posture in which a case comes before the court? What is the actual legal question the court is supposed to be addressing? And it also implicates things like, what is your theory, the judge's theory of constitutional interpretation or statutory interpretation? So I'll just bracket those last two things because we can come back to them maybe, because those are really, that could take me a while. But I'll say a little bit more about the types of cases that are so in the news right now and that I've been talking about. When you seek an injunction from a court, you have to prove a few things. So for a preliminary injunction, you have to prove likelihood of success on the merits. So you have to show that you're likely to win. You have to show irreparable harm if you don't get the injunction. That was what I was referring to before when I said the court seems to think that any time the administration is told no, that's automatically irreparable harm to it, which I don't think is the case. But even if that were true, the courts are also supposed to take into account the harm to other people, the other party, and the public interest. That's sort of often referred to as the balance of equities. And this comparable, that's what the plaintiff has to show when they go into court to get a preliminary injunction in the first place. And when whoever is seeking an emergency stay goes to a court to ask for an emergency stay, they basically have to, it's very comparable. It's not quite identical, but it's very comparable. They're flipped, right? They have to show, well, we have a likelihood of success on appeal. So in this instance, the administration are suffering irreparable harm. And then this balance of equities. So that's exactly where these real world consequences are supposed to come into play. And again, it does not appear to me that the Supreme Court is considering those consequences at all when it's ruling on these executive stays, on these emergency stay applications. They are just to speak to immigration law, I mentioned a few minutes ago these temporary protected status for Venezuelans that the administration removed. Lower courts said no, impose preliminary injunctions. And I'm not expert in this area of law, and I actually haven't read those opinions, so I can't speak to I can't speak directly to the merits. But I can say that when the Supreme Court granted the emergency stay, they gave no apparent consideration to the interests of these thousands, hundreds of thousands of people. I'm not sure how many Venezuelans are subject to this, but tens of thousands of people certainly who immediately became illegally present in this country through no fault of their own. Right? One would think that that is that would be relevant in this balance of equities. It should be relevant in the balance of equities. It's in the doctrine, but it wasn't addressed. So that's one answer to your question.
Yeah, thank you. For civic leaders, advocates, and future candidates, the people who are here with us in our virtual room tonight, watching all these legal battles unfold, how do you recommend folks engage in this current moment?
There are so many ways to engage in this current moment. And one thing I would say is if you're not a lawyer or you are a lawyer, but you do something that is not directly related to anything that we're talking about here, or even if you are a lawyer who does do this kind of stuff, don't think that it's only lawyers who can affect what's happening in the world. That's absolutely not the case. Lawyers are doing, there are some amazing lawyers doing amazing work. And, there are all these injunctions out there, some of which have been sticking. Those battles are going to be ongoing for a long time. And if you want to support that type of work, there are organizations you can donate to. But the lawyers alone are not going to fix the problems we have at all. And I think it's crucial that people find other ways to engage, whether that's getting involved in electoral politics, running for office yourself, supporting candidates who believe in the things you think are important, donating to them, campaigning for them, whether that's contacting your elected representatives to tell them what you think. And that's important, even if generally they vote the way you would want. It's good for them to hear from people because they hear from people who are mad at them. So it's good for them to hear from people who are happy with them too. Engaging in mutual aid in communities. I mean, it's just incredibly important to be building community. I think we can see how important that is when we had Operation
Midway Blitz.
Midway Blitz here, and there's still some of that going on, and I imagine they'll come back. And what's happening right now in Minnesota, the mutual aid and community effort is crucial to pushing back on what is really anti-constitutional, anti-democratic, extremely dangerous authoritarianism. So there are a million ways to engage. Pick one. There's not going to be, or pick three. There's not, nobody knows. There's no magic path. There's no map, or how-to guide to get out of this. There's, if we follow the following steps, everything will be fine. So nobody knows exactly. All I can say is if people don't engage and don't build community and don't push for the things that they think are important, the values they think are important, democratic accountability, then we won't find our way out. Mm-hmm. So my advice is do something that's meaningful to you and do it.
Yeah, I just want to echo what you said about mutual aid groups. I've gotten involved with one where I live in the city in Avondale, and that was something I hadn't been involved in a couple years ago, and now is central to our neighborhood and the way I show up, and that has been really helpful and grounding when everything feels untethered. Yes.
Yes.
And what you said of que te llama la atención, as they say in Spanish, what calls your attention? Not everyone has to be a lawyer, and even as a lawyer, how do I plug in? So follow that. I want to focus on the fact that this forum honors our founding mother, Dawn Clark Netsch, whose career reflected a deep commitment to the rule of law and public service. Looking ahead, what gives you hope about the future of American democracy and what still feels most at risk?
Well, honestly, what's happening in the Twin Cities gives me a lot of hope. I mean, obviously, it also is obvious what's at risk, right? The ICE raids, the complete lack of any apparent constitutional guardrails. I just read today that apparently ICE has concluded that they don't need a judicial warrant to barge into somebody's home. I mean, that's certainly how they've been behaving, but that had never been anybody's understanding of the law. So obviously, I can say a lot of things about what's at risk, but what gives me hope is the community response that we're seeing. People who are, I think, never would have imagined themselves standing outside in freezing cold weather, sometimes screaming obscenities at people who are coming to abduct their neighbors. That gives me some hope. And I actually wrote a piece for SCOTUS blog about a month ago talking about the Fugitive Slave Act and how during that period of time, the pre-Civil War era, there was a lot of, the law was horrific. And at that point we hadn't amended our Constitution yet. We had slavery. The law was worse in many ways. But people nonetheless did behave in many places the way the people in Minnesota and the people in Chicago have been behaving. They came out, free African Americans, escaped enslaved people, white abolitionists would come out and send out warnings when there were slave catchers in a neighborhood. They would sometimes surround the homes where escaped enslaved people were staying, or jails where they had been taken, or sometimes the places where the slave catchers were staying. And they didn't always prevail, but sometimes they did. Sometimes they drove those people away. And I think, that was as dark a time as we are in now. That was a darker time. And it lasted for a much longer time than we've been facing. And yet there were people who were willing to stand up and say, no, that's not what I believe, or not just that I disagree. It's not what I believe in as my vision of what our country is and of my vision of what the law should be. And I think that they succeeded to an extraordinary extent eventually, not as fast as I wish they had, as we all wish they had. So I look a lot to that era, to the civil rights era, to the perseverance and optimism that people who faced much more frightening and things than I mean, there are people today facing some people are facing extraordinarily frightening things. I don't mean to diminish that, but there isn't slavery stands alone in its horrors and brutality and for how long it lasted, and yet people stood up and said no.
All right, let's pivot to our questions. We've got a very engaged crew, which is wonderful to see. Let's do Jan Alexander's first question in the chat. If the Democrats can achieve a majority in either the House or Senate come November, is it actually the case that they can stop? Will there be a stop to the administration's illegal activities? Given that the executive branch clearly has no respect for the law, how can a Democratic majority actually restore power to Congress, especially given the makeup of the Supreme Court? Will not every challenge to executive power wind up before the court, and the chaos will it continue? What are your thoughts on that?
Well, I think it's, I would say a couple of things. First of all, obviously, the midterm elections are incredibly important for trying to halt what's happening. They also, even if the Democrats were to take the House and the Senate in 2026, that would be the beginning, or I wouldn't say we're at the beginning, but that would only be one step in what I think is going to be a many years long process at best of fully restoring the rule of law and democracy. So what will Democrats be able to do? Well, to some degree, they'll be able to not appropriate money. Now, Donald Trump might try to spend money anyway. He's sort of setting up this slush fund of Venezuelan oil money in Qatar as if that doesn't, that he could just spend it. It's unclear what he thinks he's going to do about that with that money. He said either today or yesterday that he doesn't think he needs congressional approval to send everybody a $2,000 tariff dividend check. I think that is clearly not the case. But so will he continue to have this extraordinarily adventurous overreach of executive power? Of course he will. But Democrats can make it harder by making it more obvious that he's violating the law, violating the Constitution. Democrats will have oversight authority, even if they only take one of the houses, where they can hold hearings. They can make things more public. They can make it clearer what they would do differently, right? Like they can pass bills in, like, let's say they just have one house, or even if they have both houses, they can pass bills that either don't pass the Senate or get vetoed by the president and say, well, if, this is what we want to do, hello, American people, is this what, if you want this, elect more of us. But I think it's, just as I think it's a mistake to think that anything that, any result in 2026 is going to save us. The flip side of that is that if things go badly in 2026, well, that will be bad. But that doesn't really change what the rest of us should be doing, right? It's not, it's the, so I see this as something of a generational project. And so, yeah, there are lots of obstacles. People are going to do a lot of illegal and unconstitutional things. They already are. But that doesn't change how we should respond, in my view.
I want to raise Anna McKinley's question. What do you suspect will be the long-term effects of the Trump administration's overuse of the emergency docket? And what do you see that becoming the new norm?
Oh, gosh. It's a really interesting question. And I don't think I can really make a good prediction about that at this moment. It's notable to me that the administration has it seemed to have slowed its pace of filing these emergency applications. And the last few that it's filed, it's actually not succeeded, which is new, right? So one of those, I'm sure most people here are aware of, had to do with whether or not he could deploy the National Guard here in Illinois.
Right.
And the court, after sitting on it for quite a long time, said no, he can't, at least under current circumstances. So, different people have different theories about what's happening. Some people say, well, this is, his popularity is waning. Therefore, the court feels more comfortable saying no to him, especially since they've said yes to him so many times, so that they, I'm not a big, I don't know whether that's the main explanation. It could be a partial explanation for what they're doing. It may be that the administration, it may be that the court has taken to heart some of the criticism it's received about how it's handled the emergency docket. So I think we have to wait and see really what happens with the emergency docket moving forward a little bit before I really think we can make much of a prediction about it. I will say that in past administrations, including, the first Trump administration and the Biden administration, it was much less likely that the executive would prevail when they both administrations did sometimes file emergency applications. Biden did too. Didn't prevail at anything like the rates that the Trump administration has been prevailing. So if they stop, if the next administration doesn't have the same luck, to put it, that's not really the same success rate, maybe a better term, that is likely to affect what they do.
Sure. I want to turn to Teresa McKelvey's question next. She writes, in a highly polarized environment, what policy or actions or leadership behaviors are most critical to rebuilding public trust in government, regardless of who's in the White House?
This is a little outside my expertise. I'm a constitutional law professor, but and this is also, I think, a pretty hotly contested question, at least among political operatives and politicians. But so I'm going to give you my answer, but I don't really, I don't think I can't really claim to have particular expertise. I think talking frankly about what's happening and why it's bad is crucial. And so I personally get quite frustrated when I hear Democrats say things like, everything's a distraction from affordability. I mean, affordability is really important. No question about it. Talking about people's economic circumstances is really important. But I think it's crucial to also be talking about the shredding of the Constitution and the separation of powers and the abuse of both American citizens and legal people who are here legally, but who may have once run a stoplight, and the undocumented people who are being, many of whom have been in this country for decades and really have been incredibly important members of our communities. So I think, naming all of that and refusing to, to shy away from it because some people say, well, it didn't work in 2024 to talk about democracy. I just think, first of all, that was before he did all the stuff he's doing. And it's crucial to, I think, to talk to Americans like they have a stake in our system. It's not just about what do you get, right? When you go to the store, it's about, right, what is the world you want your kids to grow up in? Do you want your kids to be able to say what they think without running the risk of being tackled and have pepper sprayed? So that's my partial view on that subject.
And real quickly, I want to address Tina Laurie Harris's question asking about, I think the question's asking regarding abortion rights where Roe was already overturned in 2022, voting rights. Do you think that there's possibility of those resurfacing at the Supreme Court, if I understand the question?
Yeah, so I guess there are a couple of answers to that. One is, on some level, sure, people can, so people can bring challenges to abortion restrictions and try to litigate them to the Supreme Court and try to get the Supreme Court to reconsider Dobbs. I don't see that being successful anytime soon. It doesn't mean it shouldn't be tried. I actually think that the anti-abortion movement is, although I profoundly disagree with them, they're kind of a model for how to use the tools of the Constitution to achieve your vision, right? They worked on this for 50 years. So it didn't happen overnight. And they worked hard on messaging, and they worked hard on electoral politics, and they worked hard on understanding the relationship between electoral politics and judicial appointments and their goals. Those are all things that people on the left can do and should be doing, but you have to. It's not a fast time horizon. On the other hand, I do think that there is some possibility, meaningful possibility, that should Democrats retake the White House and both houses of Congress at some point in the, hopefully in 2028, but maybe another time after that. I think court reform is a crucial part of our efforts to restore full democracy to the country. That's in part because I think this Supreme Court's jurisprudence is on questions of democracy is extremely bad and dangerous and anti-democratic. But it's also right that this court, there is supposed to be, even in our somewhat undemocratic constitution, there is supposed to be a democratic input, small d democratic input into who serves on the Supreme Court, and therefore, what kind of a justice are they likely to be? And that has been severed. That input has really largely been severed by a variety of factors, including strategic retirements, timed retirements, unexpected deaths, unwillingness by Mitch McConnell and the Republicans to consider Barack Obama's nominee in 2016, rushing through Amy Coney Barrett in 2020. The Democrats have, as I imagine most people here know, out of the 9 justices, 3 of them were appointed by Democratic presidents. The last time there was a majority of democratically appointed Supreme Court justices was in 1969. That is so that 6-3 skew that we currently have is despite the fact that since Bill Clinton became president, the Republicans have won the popular vote for president only twice, 2004 and 2024. Nonetheless, we have the 6-3 skew, and some of the most recent nominees, all of Trump's nominees, for example, were confirmed by members of the Senate who collectively represent millions fewer Americans than the members of the Senate who voted against their confirmation. Now, all of that is perfectly constitutional, not suggesting that, but it has had the effect of really severing this small d democratic input into the court. And the court is, I think, right now, really, in many important ways, it is an obstacle to democracy. So I think there are many different types of court reform, and I'll just throw out, I think we're over time, so I'll talk quickly, but I used to be opposed to adding seats to the court. I used to think, that's just going to start a tit for tat. Everybody, whenever one party's in charge, I'll just add more seats. I've come around to thinking it's actually quite essential. And in some ways, I've come around to thinking that the best way to do it would be to actually add a lot of seats. So instead of some people say, well, add 4 seats and, let a Democratic president appoint 4 Supreme Court justices. I think maybe, but what if we added 20 seats and then, however, you would stagger how they got appointed or whatever. Also, there should be term limits, but that may require a constitutional amendment. Adding 20 seats to the Supreme Court does not require a constitutional amendment. And what one effect that might have is it certainly would make each individual justice less powerful. It would make each individual nomination less fraught. Many people think it would make the court start behaving more like a court. I mean, the Supreme Court is always going to have some questions that it decides that are very big, and have involve big questions of values that are conflicting, and it's not, despite what some justices might suggest in their confirmation hearings, it's not like you can just look at all the materials and find the right answer. It's just not the way it works. And that's always going to be true. But there are ways of trying to minimize the anti-democratic nature of that. And I think adding more justices is one.
Great. Well, many, many thanks, Carolyn, for sharing your insights with us. I found them both informative and grounding, which is much needed at this time. We appreciate everyone joining us to honor IWILTA's founding mother, Dawn Clark Netsch. And hey, if you're not already receiving IWILTA's emails, please sign up through the link Sophia will go ahead and drop in the chat. Also wanted to plug, keep an eye out for the virtual spring fundraiser in May. We look forward to seeing you all more in 2026 and have a good night.
Thank you,
Good night, everyone.
Carolyn.
Thank
Thanks,
you for having me.
Colleen.